Hi kids, my name is Nur Adlina and today we'll be learning about strict liability and how it affects drunk drivers. So without further adu, let's begin. So, what is strict liability? Before we can answer this question, try putting yourself in this scenario. You went out with your friends to go karaokeing. You decide to drive your parents' car to the karaoke bar. You sang and drank a lot of alcohol with your friends. You later say goodbye to your friends and decide to go back home. You decide to drive your car even though you felt dizzy from the alcohol as no one was available to send you home. While driving, suddenly you heard a loud crash and before you knew it, you got into an accident and accidentally hit a car in front of you. After going through a test, it was found that you were in fact too drunk to drive a car. You were charged under Section 44 of the Road Transport Act 1987 for driving under the influence of intoxicating liquor or drugs. You stated that you did not intend to drive the car while you were too drunk, as no one was available to send you home. But the court stated, I don't care whether or not you wanted to drive or not, because you were caught driving and therefore we shall punish you. Now you wonder, can the court punish you for something you did not intend to do? Maybe there was no Grab or taxi available to send you home, or maybe your friends were too busy to send you home, like you stated earlier. So you had no choice to drive the car. The answer here is yes, the court can punish you, as the offence falls under a strict liability offence. So, what is a strict liability offence and how is it different than other offences? So, in other offences, usually when you commit an act that is considered wrongful in law, the prosecution in court has two things to prove. Firstly, that you have committed the offence in question, and this is called actus reus, and secondly, whether you had the intention to commit the offence, which is called mens rea. From here, we shall refer mens rea as intention. However, in strict liability, it is offences where the prosecution does not need to prove that you intended to commit the wrongful act. They only need to prove that you were indeed the one who committed the act. For example, in the case of Milan bin Abdullah versus public prosecutor, he was punished for committing a wrongful act even though he never wanted to do the act in the first place. This is strict liability, an offence where you will be punished despite not having any criminal intent to commit the act. Now you wonder, why would a law allow someone to be punished despite them not wanting to commit the wrongful act in the first place? So this is because in criminal law, there are certain rules or provisions that do not provide the requirement for you to have wanted to commit the act in order for you to be punished. For example, in the context of drunk driving, there is no wording in Section 44 of the Road Transport Act 1987 that states that you have to have wanted to drive the car despite being too drunk in the first place in order for you to be punished. It simply states that as long as you drove the car while you were being too drunk, you will be punished. Therefore, this is an example of a strict liability offence. It is when the rule or provision itself is silent on the matters of whether or not you had the intention to commit the wrongful act in order for you to be punished. However, this seems to be a bit unfair, isn't it? A person should not have been accountable for an act that he never intended or wanted to do in the first place, right? He should be allowed to defend himself, am I right? Therefore, there are many approaches to resolve this issue. Sometimes the court will just have presumed that you have intended to do the act in the first place, and only then you will be entitled to defend yourself later when it is proven that you did in fact commit the act. This approach is called strict liability with the presumption of mens rea. However, sometimes the court does not need to presume, as they believe that as long as you committed the wrongful act in question, therefore you are accountable for your actions. This approach is called strict liability with no presumption of mens rea. Because there is no mens rea, there is no defense, right? This is the basic idea. However, there is a distinction between strict liability with presumption of mens rea, which is intention, or strict liability without presumption of mens rea, or without presumption of intention. Some courts have adopted the position under strict liability without presumption of mens rea that there can still be a defense, and the usual defense will be mistake of fact, such as, oops, I'm mistaken. Therefore, strict liability, there is a possibility of defense by arguing that there is a mistake. That is, you can prosecute without the need of mens rea, but you still have the basic defense, or you can be punished without the need of mens rea, or without the need of proving that there is intention. We need to see whether or not the court needs to presume you intended to commit the act, or the court does not need to presume and is entitled to punish you either way. In criminal law, there is a way to decide on this. As in criminal law, the court decided on this referring to the case of Cayman HK Limited versus AG of HK. Basically, in this case, the court has listed down certain circumstances of when the court should or should not presume that there is intention by the person to commit the wrongful act in question. Firstly, we presume that there is intention when the wrongful act in question is truly criminal in nature. This means that when you read the rule in the rule book, or in this case, in the statute, you have to see what kind of wrongful act is this. Is it truly bad as it seems, or is it truly criminal in nature? For example, when you consider driving while being too drunk, do you consider it to be as bad as committing murder? Murder is a wrongful act of killing someone. Therefore, is being too drunk while driving similar to killing someone? Before we can decide on this, we also have to see whether or not the rule intends to control the persons, or is it regulatory in nature. For example, it is an offense if you drive above the speed limit, right? As you can be fined. This is a simple rule, so the court won't care about your reasons of speeding, such as maybe you need to go to the toilet or need to go to the nearest gas station. They would simply fine you, as the rule is a minor offense that intends to control you. Therefore, it is a regulatory offense in nature, and it has nothing to do with is nothing as bad as other criminal offenses. However, a rule such as committing a criminal offense such as murder is not simple, right? Therefore, the court will be willing to hear the reason on why you did what you did. Thus, they will presume you have intended to commit the act so that you later can exercise your defense under Chapter 4 of the Penal Code. Therefore, in the context of drunk drivers, the act of driving while being too drunk might be as equivalent as committing murder and not as simple as driving above the speed limit. This is because when you're driving while being too drunk, it is similar to not knowing whether you will get into an accident or not. Or even worse, maybe you would hit someone else's car, thus hurting the people around you. You guys have heard of the news of a motorcyclist being dragged by a car that was being driven by a drunk person, right? Isn't this therefore as scary and a serious offense as murder? Because the person died from being dragged by a person who was too drunk while driving a car. Therefore, driving while being too drunk can be considered as a criminal offense in nature, as alcohol in your body is unpredictable and is definitely a vicious demon inside your body handling the vehicle on the road. Thus, the court might need to presume that you have intention to drive while being too drunk. But however, this presumption may be wrong, as the main objective of the rule book or statute is to ensure people are safe. This is illustrated in the case of PP versus Teo Kwang Kiang, in which because the purpose of the statute or the rule book was to protect the people or the public, therefore there is no presumption of intention, and thus the court doesn't care whether he intended or not intended to commit the act or the wrongful act, as he will be punished either way. Therefore, it can be said here that the intention of the rule book or the statute in this situation, which is the Transport Act 1987, is that they want to protect the people around the car while it is moving in case there is an accident that happens. Thus, since the statute or rule book main purpose is to protect the public, therefore the court does not care whether or not you intended or did not intend to drive the car while you were being drunk, and you will be punished nevertheless. Furthermore, we cannot presume that the person intended to drive while being too drunk if the main provision or main rule was for the benefit and protection of the public. For example, in the case of Lim Chik Ai versus R, the court held that it was okay to hold you accountable despite the lack of fault, so that in the future you will teach others not to do the same offense. For example, if the rule wanted to protect you and your friends or the public from harm, thus the court will not care if you did or did not intend to drive while being too drunk. Thus, it is clear here that the rule's main aim was to protect people from getting drunk or hurt by drunk drivers, as held at Section 44. Therefore, it must be presumed that intention is not needed for someone to become guilty of driving while being too drunk. As long as you drive while being too drunk, you can be punished. However, let's say you were punished by the maximum penalty, as in imprisonment for 3 years. Then you think you should be given the opportunity to exercise all defenses available, right? The answer is no, as the rule's main purpose was not to allow people who are too drunk to drive to avoid people from getting harmed. The court cannot simply say that since you are going to be in prison, you are allowed to exercise all the defenses available. Thus, this is wrong. In conclusion, from all the reasons stated, the court must presume that the drunk drivers do not have the intention to commit the act, and thus they will only have the right to defend themselves under mistake of fact. As will send a strong message to people not to be too drunk while driving, and also for people not to drive while being too drunk. The person who is punished over the offense is only allowed to defend himself by mistake of fact. Therefore, this is indeed necessary. I hope you guys understand the concept of strict liability, and thank you for listening. Goodbye.